Page 16, State versus DeCastro versus State Nevada, C 381730. Well, you already filed this brief.
Yes, all I was doing was motioning. When I do it in the Supreme Court and I go over the 30 pages, we have to file a contemporaneous request saying, could we have excess page number? So I did that.
What if they say no? Did they strike the last 10 pages? I'm gonna grant it.
But in Margaret Rudin, they actually said no, and I remember I had to cut back some, so yes, but that's the only time, and it was 120 pages.
Just lower the font.
How many did they allow you in that case?
I don't recall.
Jeez, okay.
I don't recall, but
I'm assuming the state has no opposition.
No, I have no objection.
Okay, so it's granted, and the only thing that motion to admit, that stuff was all presented at the trial level, right?
no, part of it was, and I don't think the state has an objection to that part. I was concerned because the Supreme Court on Appeal said we have to make sure that the higher court, their court receives everything that was utilized below. So there was a video, body cam video from the officer that the state admitted. I did not know how to generate it so that this court would have it, and I was concerned the state could possibly say that I didn't do anything to get the evidence before the court. So I just motioned the court to say, hey, could we please make sure that that's included? I don't think the state has an objection as to the dash cam.
Anything he uses that was presented at trial, I have no objection to. Obviously, the other exhibits that he puts in, that was not anything that was presented at trial. We would have an objection to those exhibits.
And there were some that I have just included. So when the court asked me that, yes, there are exhibits that were not included in trial, they're not mentioned in trial. And so I am saying, could the court consider that? And so I think maybe
Oh, you weren't at the trial level. You weren't the attorney.
No, and we are raising ineffective assistance of counsel as well. So that would permit me to go outside of the record. I may be filing something because he is in custody, a separate writ. The issue was already raised, but I may just raise it as a writ so that I can then explore issues outside of the record. But I know that Mr. Chen objects to the exhibits that were not admitted, and there were a few that I requested.
You're going to ask the court to consider.
Yes.
So it's a direct appeal and I guess post-conviction.
Yes.
Mr. Chen.
I don't know if procedurally it was absolutely correct, but at the end of the day, I'm allowing Mr. Oram to file what he wants to file in this appeal. So whether it's the direct appeal and treating it as a petition, if the court wants to construe it as a petition, that's totally fine with the state. We'll just respond to it on the merits.
And that probably will save some trees, because I was going to, having heard some of the state's concerns, I thought about filing a separate writ, but if we can, I may refile it just with the form, because I'm concerned that on appeal, the Supreme Court, if there was an appeal, the Supreme Court could say this wasn't properly preserved. So I may do that, but it wouldn't slow anything down, because I'm not going to raise anything that has not been raised already.
Okay, so it's granted. You can prepare the order on these. And I think July 10th, right? Everyone's on track to meet that date.
Yes, sure. Okay, thank you very much.
Yeah, thank you. Have a good day.